KLK 101.5 FM. Good morning to you on Wednesday. This is Community Conversations. Little woman is back in the studio. You know, I've been gone. Well, I haven't been gone at the time. I've been gone from the airwaves earlier this week. I just want to give a special shout out to my co-host, Mrs. Willhite, who has done a phenomenal job of holding things down while I was going, part of running a radio station. I mean, sometimes you have to do things other than be behind the microphone, but I have left the show in good hands, and Quick has done a great job. So thank you for all that you do for the station. My guest today on Community Conversations is Scott Willhite. He is a local attorney. This is our monthly Ask the Attorney Day on KLK. We do this every second Wednesday of the month right here on KLK 102.5. We're going to open up the phone lines in a little while to take your questions, but we are going to start off with some of our own questions, and I'm going to start with a question that was posted on our Facebook feed earlier when we announced that this interview was going down. So give me just a second, and I will get to this. All right, our first question comes from Alicia Russell. How long does the spouse have to be gone to get an annulment due to abandonment?
An annulment is a little bit different process than a divorce. So we've got two different processes working there. Divorce can be obtained in 18 months separation. So that's sort of one direction. But an annulment is more of a process that is up to the discretion of the judge. And so I'm not sure that we can say there's a specific period of time that they have to be apart. But an annulment is something based on a fraudulent situation where someone enters a marriage and the opposing spouse discloses some things about themselves. It may be a disease, a past serious criminal, some serious criminal actions, things of that sort that would have made that person say, I wouldn't have married this person had I known that. So two separate processes and two separate time frames.
But basically, simply just you get married one day, and then a few months down the line, the person leaves and never comes back. That in itself wouldn't be a reason. Not
necessarily. You can get a divorce under the circumstances every 18 months, but in an annulment, you would still have to prove some sort of fraudulent type circumstances to have the actual marriage annulled, because an annulment says it's as if it never happened.
All right, well, Mrs. Russell, we definitely thank you for the question.
Well, so I'll piggyback with that question concerning marriage. Was saying you file a divorce and the other spouse simply does not want to let go. The marriage is over in two different states. The one spouse will not sign the paper, they don't want to let go. What can you do to get the judge to see?
Well, it's not unusual for one spouse to say, either for religious reasons or just they still love the person or whatever the reason is, they don't want to let go. So one way you resolve a divorce or a domestic dispute is by agreement. That would be if the person signed the papers and sent them back and it was over. The other way is for a hearing, and the moving party, the first spouse would have to prove grounds for divorce. And you can have grounds for divorce. We have a term, Arkansas general indignities, which means a person has acted, with such a lack of dignity. Either they've emotionally or physically abused the other person, so that a judge should grant, the divorce.
Okay.
So whether there's an agreement or not by the divorcing spouse, the person may be able to get the divorce if they show circumstances of general indignities or the 18 months. There's various reasons to pay the divorce.
Okay. Now there is a legal service. You can print your own papers online. You just pay a fee once you go to court. What are your views and thoughts on that? Would you recommend that, or would you recommend people go through the traditional system of
Well, obviously as an attorney, I undercut myself. I think it's always better to have representation of someone who has experience, not only of the process, but of the judge.
Okay.
Each judge is different. Each judge has a little bit different viewpoint on different issues, and so some of the experience that helps. The other thing is the forms you get online may not be tailored to Arkansas law. They may be applicable generally over the 50 states. So there may be variations that you don't know about if you use those terms.
Okay.
Speaking with local attorney Scott Willhite, this is our monthly attorney. We're talking about various matters in relation to family, divorce, child custody, things of that nature.
I asked you a question early on, and I want you to please share, the answer with the viewers.
And listeners.
I'm sorry. The viewers and listeners.
You've been looking at that live feed, right? You've been running the show.
Yeah.
We are broadcasting live on Facebook and on YouTube. So if you are watching on either, feel free to leave your questions or comments on the feed, and we ask them to Mr. Scott Willhite.
Okay, so you're in court, and even you're going for custody. Two parents are going for custody. One parent has things seemingly stacked in their favor, but unfortunately, their behavior in court is unsavory. Does the judge have the discretion to judge, even though evidence is pointed one way? Can the judge make a decision another way concerning whatever is brought before him?
That's a great question, because when you go into a court proceeding, the evidence may seem stacked against one party, but what happens in the courtroom is the most important information the judge will receive. Evidence maybe outside court may suggest that this one person is such a great person, they're involved in this and that. But what happens in the courtroom is the judge assesses one parent's treatment of the other parent, one parent's treatment of the court authority. And I think judges are moved by humility, compassion, the things that we all seek to have in relationships, to see, even though these people have a dispute, they may not know each other, they may not want to live together as husband and wife, but can they treat each other with respect? Can they teach that child respect? And so I think how that parent treats the other parent in court is important.
Okay. Okay.
But yes, I think that the circumstances can change, so the opposing parent can get custody. It's what's in the child's best interest as the evidence shows presented in court.
And just to piggyback off of it, this is for all the men out there. Traditionally, past, at least when guys they experience frustration, they want to be involved in the child's life. They want to be there for the child, but the mother holds bitterness towards the child, not towards the child, but towards the father, and basically uses the child as a pawn, unfortunately. And so basically, no, you can't see your child, and then the mother runs off, and the child moves to other states, won't answer calls, and now the father's taking care of his obligations. He pays his child support on time, never is late. He makes an effort to see the child, makes an effort to call the child, but the mother is out of angerness and bitterness running it away. So what recourse, does a man have in this situation? Because, for men that I've talked to in the past, they've been frustrated, they go to court, and basically they feel like they're not getting anywhere.
Anytime there's a parent who obtains a divorce decree with a custody ruling in Arkansas, and that person moves away, that qualifies most likely as a change of circumstance, allowing the dad to go back to court.
So what if they're not married?
Well, it doesn't really matter. It's any sort of custody arrangement that results in a material change of circumstance, allows either party to go back to court and change that custody arrangement. So, say in that setting, the dad can go to court and say there's been a material change of circumstances. He wants visitation in some manner that would give him maybe more time with the child, big blocks of time as opposed to every other week, because he can travel to another state every other weekend. So the court can tailor that specifically to the circumstance. The court doesn't have to go to the visitation schedule, which is every other weekend and every off Wednesday.
Okay, and still piggybacking off of this again. So what if something like that happens? Or even if the mother does move, she just refuses to let the father see the child, and the guy has to go to court, says, I show up for my visitation time and she's conveniently, not home, and what recourse in that situation?
If a person is violating a court order by non-compliant, by not doing what the judge has told them to, an attorney can file a contempt action against the other party. It just basically says they have willingly violated the orders of the court, and they need to show up to court to tell the judge why they shouldn't be held in contempt. Contempt, if you have a fine of contempt against it, it can be a fine, it can be more restrictive orders, it can be jail. So the judge has the power to make sure the party is compliant. And let me say this, in the typical visitation order, standard visitation is every other weekend, every off Wednesday. That's supposed to be a minimum. Say the dad there is getting standard visitation, and the mom says, I'm not giving you anything more than that. It's really supposed to be a minimum for the dad. It's supposed to be that he gets that plus anything else that he may be able to the mom into. But typically, that's seen as a maximum, but it's really not supposed to be a minimum visitation guideline.
I'm sorry.
No, I'm just going to say phone lines are open at 870-277-1180. If you have any questions for Mr. Scott Willhite, we'd love to hear from you. Once again, the phone number is 870-277-1080. I know Mrs. Farrell listening. I guess she may call in if the baby's sleeping. If she didn't call in, we know that the baby's up in the way. So shout out to you, Mrs. Farrell.
Okay, so I know we're talking a lot about, family issues right now, because a lot of people deal with this. And then in this day and age where you see so many people that have children together, they're not married, or they may get married and decide it was fun at the moment, or it was a good idea at the moment, so now we don't want to be together, and now you have a child together. So we've seen the dynamics of relationships in this day and age change what even just 10, 20 years ago. So I just want the people to have more understanding, like, do not go into these situations lightly. When you first getting married, it's not something you go into lightly, but then having a child in the mix, definitely something I can get into. Right? I want to ask about child support, and okay, say the father, I'm going to take the gender roles off, I'm sorry. Say one parent's ordered to pay child support to another, and it's a pretty hefty sum, and then, the other parent, the parent that's paying, say they get summer visitations with their child, does the parent that's paying have the right to ask the judge, okay, if I'm going to have a child for the whole summer, can my payment stop for that moment so that I can still have adequate money to do the things we want to do for the summer, versus mom or dad still getting that at me, and I'm still, child's with me, but they're getting the money.
That's a great, because typically, if one parent is paying the other child support, then that parent has a greater deal of time to spend with the child than the other parent. So that's why the parent who is taking care of the child, predominantly, the most of the time, gets child support. If someone had a full summer visitation, it would be unusual for them to pay full child support under most circumstances.
Okay.
Child support is supposed to be based on sort of the unequal time, as I said. So maybe they're joint custody. Maybe there's a reduction of a child support out of the fact they spend more full amount of time together. But we've gotten push from the state to make child support mandatory in most circumstances, and that one parent has to be the primary custodial parent. So it could happen that someone is spending the majority of the summer with the child and still paying child support, because they're set at a time, usually the same time. When the custody arrangement and child support are set at the same time, knowing that child may be with the non-custodial parent a substantial amount of time.
Okay, and I have two questions to piggyback off that, and then like Bila, I'll make this gender neutral. First part is, if the person you have a person that's paying child support and the parent that's receiving child support, what if the parent that's receiving child support feels that the person who's getting the child support is spending the money fraudulently, not using it for the child needs, but using it for personal needs? And then the second one is, what if you get on this quote unquote treadmill where it's on child support, loses his or her job, then gets behind, but because, and they're looking for a job, they can't find one, and then they wind up in jail because they can't pay child support. Well, they're sitting in jail, so they can't, they work to pay it, and so now they're on the hamster wheel. So, Scott, we'll just kind of give you across both parts of that.
Okay, let me take the second one first. I see that a lot. I do a lot of workers' comp cases, personal injury cases, so I see people who are unable to work for some reason, out of work. Maybe they get fired or just injured and can't work, and all of a sudden their child support has a rearage. What do? The most important thing you can do if you have an injury or you lose your job is get back in court as soon as possible, because the date you file a petition asking for a reduction, that's the date the court has really jurisdiction to make a change and try to stop the arrearage. Now, the court may not totally discount the loss of job, but I know they look at it into consideration. That is a change of circumstance. It may not be if you your finger or something, but if you have a substantial injury or substantial incident on a job for some reason that's not your own fault, you don't just quit. The court will say, I'm going to reduce child support for a period of time. I'm actually doing that very thing for one of my clients who's a workers' comp, hurt his back real bad. We're trying to get back in child support and get it reduced over the long haul because he just can't like he used to. He has a long-term limitation. So getting back in court as soon as possible in front of the judge who set the child support amount is very important.
Okay.
Tell me your first question.
And the first part is, what if the person who is paying child support feels the parent is using fraudulently?
That's a harder issue. There has to be some discretion on the custodial parent as to how they use the money. But I see that a lot, that the non-custodial parent will say, well, they're going out to the bar, they're going out buying jewelry, they're getting into the child. That's a difficult issue for a judge to deal with because, like I said, the custodial parent discretion, they may be going to Kroger and buying food with part of it and then spending the rest of the money on something else. But I haven't seen a lot of specific direction to a custodial parent of how the money is supposed to be spent. As long as the child's food, shelter, and clothing are taken care of, I think the custodial parent gets a pretty broad way to use the money.
Once again, I'm speaking with Scott Willhite, local attorney. This is the Attorney Day, second Wednesday of every month on Community Conversations. This is Gaelic K12.5 FM. Online still are open at 870-277-1000. We also taking questions on our Facebook live stream. We do have a shout out to and Tina Neal. We appreciate you for doing our live stream.
Okay. I want to switch gears a little bit. I know people are like, oh my God, they're talking about child support, divorce, and blah, blah. But I want you to explain to the people, attorney-client privilege. We hear that a lot. Some people don't understand what that means. Some people think, well, maybe I can tell my attorney anything. He or she can't say anything about it once we go to court. Kind of tell us what the attorney-client privilege entails. Are there some limitations? There's some situations where you have to use your own judgment and say, I can't keep this stuff.
Years ago, I remember the movie The Firm came out, and it seemed to be based totally on that attorney-client privilege sort of thought. But attorney-client privilege simply is a sort of a shroud of secrecy. And quickly, if I'm your attorney and you and I are sitting by ourselves talking about a legal issue, not just generally talking. It's not like we're talking about the Red Wolves playing next week or something. We're talking about your legal matter.
Okay.
I cannot disclose that to anyone.
Okay.
All right? Generally, that's the general rule. You tell me something, I tell you something, we're talking about your legal matter, it's between us.
Okay.
No one can ask you about that. If you sue someone, let's say I'm representing you, you sue someone, they can't say, what did Scott Willhite tell you? What did you tell him in that? That's all privilege.
Okay.
All right? Now, if someone else, if Leganzi is there with us and he's listening, that's sometimes breaks the privilege so that someone could ask Leganzi, well, what did Scott tell Quigley?
Okay.
All right? So that is a difficult issue that you don't want to be in a situation where you break the attorney-client privilege because there's a third party present.
Okay.
Also, if you tell me you're about to commit a crime, that's also a problem. I may have a duty to disclose that. If you say I'm getting ready to go rob a bank, I've got to disclose it to somebody.
This is Community Conversations on WK102 FM. This is Ask the Attorney Day with local attorney Scott Willhite. Phone lines are still open, 870-277-1080. We'll be back at WK on 2.5 FM. And of course, we're off the air now, so if you need to hire Mr. Willhite, phone number is 972-1500. Once again, phone number is 972-1500. Okay, set it on the air, but
This is fun.
again on the
I
stream.
enjoy this.
But kind of getting back to what Bill said about attorney-client privilege, because I remember this with the Bill Cosby thing when they were trying to depose his wife, and the way they got around it is because they said, well, you're his manager, so that. And it may not even been attorney-client privilege, it may have been like the privilege the husband and wife get. And they used that to get around this because she managed him, I guess, at some point.
Manager, money wife, the manager.
So, yeah, so they,
Okay.
so, you know, that's their reason for trying to oppose her. I guess, see what, you know, what did he, you know, say in a private conversation in the bedroom, you know,
Right.
did you, these things that being accused of?
Yeah, when someone does court, they're summoned to, okay, let me start from back up. In cases such as that one, or there's a spouse called to testify against their spouse, you know, in the movies, TV, whatever, they make it seem like if you're married, then you have the right to not say anything. Is that necessarily true?
You know, and I looked at that rule for a while because I hadn't had that situation coming up.
Okay.
My general recollection is that there is some protection of the ones that I remember are the priest parishioner privilege, the husband wife privilege, and the doctor client privilege, and the attorney client. Those are the four that they have recollection. You just don't come across that. Now, physician and patient, you do.
Okay.
You know, because like if you want some medical records of Lindsay, you have to get his signature on an authorization to get that because that's private. That's between he and his doctor. Same way with a priest. You know, you can't just go and say, "Did Lindsay get this to you?" Something, you know, you have to get authorization. And I think it's similar.
I don't want to be like when I that's the reference.
I don't want to know. I got my own version. Don't cross the barrier.
But yeah, there is some protection there. I think as time goes on, it's softer and more easily penetrated by sort of what McGinsey said about the Cosby issue, that you can find ways around those in some circumstances.
Do you think, from your experience, are laws, how often are laws revised? You know, of course, this country settled back in the 1700s. I know things that happened then are definitely not happening now, even though to some degree there's nothing new under the sun, just players of the game.
Right.
But how often do you see laws? I know it takes a lot to change the law because it has to go through Congress and it has to go through all that.
I see laws change fairly regularly,
Okay.
and it's more after the fact. You know, here's something that happened, and we can't deal with it under the current law, so we have to change it. Or maybe, you know, the speed limit, or you know, the city code which was promoted. There are perceptions that we need protection in certain areas, and so the laws are different. On the other hand, Constitution, you know, there's times that people wanted to change the Constitution, and that's totally different. That's more difficult.
Underwriters and sponsors is vital for us to stay. So be sure to let me know that you thank them for their support. Now back to the conversation.
Kelly here on 2.5 FM. Back on Community Conversations. Bill Harden is here along with me. We also have Mr. Scott Willhite, a local attorney. This is our the attorney segment, which we do monthly here on Community Conversations. It's the second Wednesday of every month, so sure to tune in and make sure that you have your questions. We'll take 70277-1080. We're also on our Facebook live stream, which you can check out on our Facebook page, which is KFM, and you can ask your questions there as well.
Now, when we finished, before we went to break, you were talking about the movie The Firm. And so when Chief Elliott was there, we asked him about movie, TV versus. So I want to ask you from an attorney's perspective, how bad does TV and movie alter the reality of, what goes on in the courtroom?
I think there's a great difference between what we see on TV and what we experience in the real courtroom. The courtroom is pretty serious. We're dealing with criminal matters, or people who are injured, or people getting divorced, or arguing about custody or child support things. And there's not a lot of laughter and that kind of activity in the courtroom. Occasionally we'll have some antics that go on, but generally it's about serious matters, and we're dealing with those with very specific procedures. We have rules of evidence that tell what kind of evidence to be presented. We have rules of civil procedure, criminal and civil, that tell how the court process and the legal process is supposed to apply to each person.
Okay.
So people are thinking about those rules and the evidence and what people, reactions and entertainment. So
Okay.
Court, from my perspective, is not usually entertaining.
Okay.
Even though a while back, I think this was in Jonesboro, there was a incident where the young man, he asked the jailer to take him to the bathroom, and then he stripped naked and ran into I think Judge Blackman may have been the judge on that. Don't quote me on that, I'm not 100% sure, but he ran in the courtroom, got some more trouble with that.
Now that's one of those unusual circumstances. I think as a judge, prosecutor, whatever, you don't expect. But
have you ever seen anything like okay?
We're probably not naked men.
No, like there's a show I'm on. I want to say True TV, and it's supposed to be more real life in the court. This particular show, they show like the outbursts and the violence and things that happen like that. Have you ever seen personally like major outbursts or something like, oh my gosh?
I've heard of those, but I have not seen those personally.
Okay.
I was trying a case over in Marion a few years ago. It was a personal injury case, and my client was injured pretty bad, and the other side got a doctor to testify saying, oh, he wasn't hurt, he didn't need surgery. But I'm cross-examining the doctor. My client is sitting behind me at the defendant's table, the plaintiff's table. And as I'm asking him those questions, and he's saying, your client just needs surgery, he shouldn't have missed work. My client just yelled out, and he starts, and I had never had an instance like that because I had a jury in the box. And Judge Hill was on the bench, and I looked at the judge, and the judge looked at me, and neither one of us, I don't think, knew what to do, but he kindly gave me a recess for a few minutes so my client could sort of get himself under control, and then we went on and tried the case and finished it, and everything went well. But that's the most extreme circumstance that I've had, where there was yelling, and my client was just, I think, in agony that people were saying that he was lying and couldn't take it anymore.
Okay. Another question I wanted to ask, when you brought up jury, there are times that people say things, either party, and sometimes the judge would say, jury, ignore that comment. Okay, well, if you're depending on the jury to make the final decision, how can you trust that they're really going to ignore that comment? When they go into the deliberation room, this probably still going to come up in their conversation. So, like, at that point, should you just I hate to say dismiss the case or get rid of the jury and start all over? Like, have you ever seen that happen?
It comes up in most trials that some evidence comes out that probably shouldn't be admitted. It's just, someone blurts out something that is probably not admissible in that very circumstance, and maybe a juror is admonished to disregard that. The first thing a juror has to do when being impaneled is to promise that they will abide by the law.
Okay.
And the only thing you do is trust that juror is telling the truth, that they will abide by the law. Now, you're right. As a practical matter, you're, let's say, there's an auto accident, they hear this driver that hit someone that's done this other time. They're not going to be able to just forget about that. But I don't think it's sufficient then to start over and start a new trial. You've got people investing money and time. So it's a difficult situation, and you really do have to trust each player. The judge has a part, the juror has a part, and you have to trust that they will abide by the law that applies to them.
So, going to court and going through the legal process, it's a really serious matter. You have so many ladies like people in there, they make it, I hate to say practice, they make it, but it's a regular thing for them. They find anything to file a lawsuit on. But they don't realize that you file a lawsuit, there's still a lot of fees attached. So you may win that case, but you're not going to get out of it. They're going to get. That's another thing. Explain to the listeners and the viewers. Just because a judge awards a certain amount of money, how does it all trickle down?
Well, typically in a civil case like that, let's say you are the plaintiff, you're suing someone. You typically have a contract with your attorney.
Okay.
And the contract will say, if we are successful, the attorney gets a certain percentage. It might be a third, it might be 40, it might be 20%, on the case. Less, plus expenses. There may be expenses if you have to pay an expert to come to court. You get medical records, it costs money. You have to pay a filing fee, that costs money. So all those are deducted from whatever a judge or a jury might award you. So you're right. Let's say a judge gave you, or a jury gave you $10,000, you might only get $5,000 or $6,000 of that after the fees and expenses are deducted.
So it's almost like, is it really worth it to file meaningless lawsuits, or just kind of just let it go? Like I would get these little things in the mail. Somebody filed a lawsuit against Bank of America, or someone filed a lawsuit against, some other corporation, and you get this little notice and says, well, you be a part of it if you ever used the service from this time frame, just size cards and whatever. What is your advice on some of those things?
That's probably a class action suit. Those are not as common as they used to be, but some attorneys sort of made a living on large class action suits. And what happens in that situation is there may be one or two plaintiffs who represent an entire group of people that were similarly situated.
Okay.
Let's just say there was there may be a contract with a TV service provider that they were charging you a fee that was illegal. And someone, on behalf of a couple of the plaintiffs, a couple of the people who are using that service, for everybody involved, and they get a judgment of a certain amount of money, well, those attorneys get a fee, and then the rest of the money is divvied up between all the people who were affected. There may be thousands, maybe hundreds of thousands, who knows, but the money is divided up. So sometimes things of that nature are a requirement of class action. For instance, a judge may say to the plaintiff's attorney, you have to contact every single person who's a potential plaintiff. So it is just to finalize that lawsuit. Usually it's the principles of finalizing that lawsuit.
Yeah, a lot of times on those class action suits, the only thing you end up getting is like a little coupon or something.
Yeah. I know with the Bank of America thing, which was years ago, I ended up getting maybe one or two of my overdrafts refunded. So it kind of was, I hate to say not worth it. Not that I had to do anything up front, but it's like, okay, like you said, there's thousands of people in the suit, so it's like, why you bother sometimes why you bother.
And there are circumstances where if you were particularly affected in a right way, you could opt out of that class and you could have your own lawsuit.
Okay.
But, as you just said, there's expenses and fees associated with that you may not have to incur if you were a class member.
Okay. Another thing, I want to switch gears again. We talked off air about, how some matters are handled. whether they're in the courtroom or whether they're just in a small room with the lawyers and the client and maybe one other, some other third party person. And we talked about, guilty versus contest. Something because they don't know the legal definitions, and their lawyer may not always be working in their favor. They get caught in situations where they either have more time, more fines. I don't know. Can you kind of talk about the process and those definitions?
Well, specifically in the criminal process, what happens is, let's just say I go into court with my client. The prosecutor typically has a plea offer that they have thought about, drafted. They present it to me, and it may say, here, your client should plead guilty to these charges and do this amount of jail time, pay this amount of fine. My response typically is to meet with my client and say, here's what the offer is. Let's respond to that. We may go back and say, hey, we don't want to do jail time. We'd like to plead to this lesser offense that has no jail time and less penalty, less fine. And so I speak with the prosecutor, and we see if we can find some common ground to resolve that. Because the ultimate issue is if I can't resolve it with the prosecutor, we have to go to trial or enter a guilty or no contest plea. And it's just a back and forth process. As you might know, you give a little here, you take a little there, you end up with something that maybe you don't love, but you can live with. And most people, as we discussed off air, they don't want to go to jail, lose their job, and have a situation where they're incarcerated for some period of time. So some people, for fear of going to jail, plead guilty, and that's unfortunate, but it is a reality of our criminal justice system.
In the cases that you handle, you say you handle more civil versus criminal. Even in those cases, have there been times when the plaintiff, the other party presents you with something, just as a workers' compensation, and the company, whoever is representing you, they present you with a deal, and it's either take the deal or go to court. Have there been times where you're like, okay, let me really go through each and every line of this paperwork to see what is really the best deal for my client?
And I have to do that because most workers' comp situations, my client needs medical care and is off work. And so it's a crucial situation if they get some sort of help to get them back to a position where they can work and earn a living for their family. So, yeah, I have that almost every day.
Okay.
I probably have 150 open workers' comp files right now. So every day I'm looking at a case to say, what can I prove in court? Is a doctor who says this person should be off work? Is there a doctor who says this has a legitimate injury? And then I have to discuss with my client, do we want to go to court and try to prove this, or do we want to accept this offer or maybe respond in some way that we don't agree with it, but we ask for something different? Someone may come and say, we'll pay $1,000 to settle this, and my client may need medical care. And it may be a situation where money doesn't really matter to them as much as getting the medical care, and I have to go to trial.
Okay. And can you maybe talk about why some trials last so long?
And some trials are resolved within an hour.
Yes.
Well, most of my workers' trials are resolved in a short time,
Okay.
an hour or two, because there's a limited number of witnesses. We may have 1 or 2 or 3 witnesses, and there's a limited amount of evidence and issues considered. In workers' comp cases, the medical records, which are probably the most important aspect of the case, are admitted without the necessity of a doctor testifying or any sort of medical professionals. So I go into a workers' comp trial, I hand the judge the medical records, and I say, here are my 2 or 3 witnesses, and the judge won't let things drag on. He wants to hear a few issues and move on.
Okay.
That's as opposed to a civil trial, where you may have a very, very difficult issue to tell the jury about or tell the judge about. It may be an issue that takes a day or two just to explain what the issue is. Maybe a difficult injury where medical testimony is on, say, one testimony, like I said earlier, this person is not injured. The other doctor says, oh yeah, they were injured, here's why. Not only that, but in a jury trial, it can take you a full day just to pick a jury.
Okay. So I know sometimes it's hard, but once you leave the courtroom, do you find yourself taking some of these cases home with you?
I find it's difficult not to.
Okay.
I I try to get my cell number for that very reason.
Okay.
I usually take them home, prepare the night before, 2 nights before. That's sort of my standard practice if I have a trial. Is I have to file it home, and I'm reviewing it to make sure I understand every fact. Because as an attorney, you need to be more up on the facts than anybody in the courtroom.
Okay.
But my heart goes out to these people really who have lost jobs or who have been injured and can't work and are really trying to do the right thing. Or maybe they've lost custody and a judge has really perceived them in a way that they're not, that's really not them. Things of that sort. And I take those home every day in my mind and try to figure out ways that I can get justice back in the courtroom. Because that's really what we need today. We've got courtrooms that handle matters every day.
Okay.
Are they really handled in a just, merciful, humble sort of way? That's sort of been
What's that catchphrase?
my catchphrase. I read because 6-8 all the time to think that's what my God expects of me is
Okay.
to be just, merciful, and humble.
Okay.
Right, and let's kind of switch gears just for a little bit. Like, tell the listeners, like, what are some of the preparations that an attorney would typically do to prepare for a case?
It really goes from case to case, Lindsay. If I have a personal injury case, what I have to do is I have to read every single medical record to know what my client's medical condition is over a long period of time. For instance, let's say someone has a car accident and they injure their back. I have to look at their medical records for 10 years or something for the injury to see, did they have a prior back injury? Is the doctor going to say, well, I know they had an MRI 8 years ago and it showed this. So there's a lot of medical information typically that has to be reviewed. If you have a case where someone loses their job, you have to look at their history of where they ever sanctioned or reprimanded or give any sort of points for being late or missing work for any other reason. So preparing is probably the most important aspect for a trial, even though it's difficult and it's the least fun. Being in the courtroom and having the interaction with witnesses and other attorneys is the most fun.
Okay.
But preparing is the most important.
I can imagine that would especially be true for a criminal trial.
Well, it's like studying for a test, for
Yeah.
long periods of time.
Do you ever deal with any social security cases?
I do. My office just started taking Social Security cases again. I handled those back in the 90s for a period of time, and one of my law partners sort of took that over for our firm, and so I didn't handle any for 5 or 6 years, but now we are taking those again.
Okay. Now I know the process can be very tedious, very frustrating for the party that is seeking Social Security.
Social Security or SSI. I'll weigh in on this. Because I've been down that road. I've seen it with my mother and with others, and it can be very difficult. A lot of times in the Social Security or SSI case, you can be almost on your deathbed and still get denied. I mean, the threshold to prove is so high. Like I know, like in my mother's case, she was disabled due to not just cancer, but the effects of the chemotherapy. Basically, her bones became brittle to where she could barely stand. And you got denied like 2 or 3 times, and all you had to, take it pretty up the chain before finally get approval. So this kind of speaks to, why you think it is difficult. I mean, yeah, obviously there's some people who fraudulently try to get on, but we're actually going to get ready to go to break. So we're going to come back at the other side of break and talk about those Social Security claims and why is that process so difficult to navigate, and what can a person do to better navigate that process. You are listening to the conversations, and this is Casey.
Drugs, they were dragging her feet. They were like, okay, we don't have a medical record yet. We don't have this. And they're literally dragging. So someone advised her to switch to another firm. This firm moved a little quicker with getting things they needed, but they still haven't made. They would come to a decision or get a decision, so it's like she's at a point where, okay, and it's not that, okay, she wants to be young, she needs to make sure she's children. If she could work, she would work, but she's unable to work. And it's like, her medical records should show some stuff that's wrong, that should be enough to say, okay, you know what, just get this lady.
That's the hard part about Social Security. You know, you got three separate processes. One is the application process for reconsideration. And then you can do a reconsideration where they look at the evidence again, a different person. And then you got the ALJ, the judge level, where you actually show up and have a hearing. And the first two are fairly efficient. You can make an application and get a decision probably within 30, 60, 90 days. The second process is pretty efficient. That's a similar time frame. But waiting for a judge to hear your case probably takes more than a year. And so you can't be on arrest. Typically they deny you those first two times. So you're waiting for a judge to hear your case. So you're looking at 2 years probably to get in front of a judge. It's very frustrating. Nobody can speed that process up.
In my case, when I first applied, it took over a year, a little over a year before they finally appointed me. The first time they said they denied me, had to do some more testing done. And so, a year and a half later, then I finally got approved. And then they had to turn paper when I first applied, because then it was proven, oh, well, yeah, she was, disabled. So, I mean, I don't wish anyone wish I could work a normal job. Unfortunately, I can't, but
it's a hard process.
But she does a great. She does a great job, though.
thank you.
I'm not the only person that said that. People say that all the time.
I just need to go to
And it's Quibila, you keep saying Quibila.
Cordelia, I'm sorry.
I've been called Quibila, and I don't know where people got that from because there's only one U in my name.
Well, I mean, I can take the different botches that my name's got.
Mine
He said that.
gets spelled wrong, but not said wrong. H-E-I-G-H-T.
Here, K 102.5 FM, and we're back on Community Conversations. Kato Wonder is in the studio with you. We have our co-host, Ms. Bela Hart, in the studio as well, and we have local attorney, Mr. Scott Willhite. This is our Ask the Attorney segment. And before we went to break, we're getting into matters of Social Security disability and SSI and why the process is so long, drawn out, and difficult. So, Scott, just give your comments on that.
First, we need to make a distinction. SSI and SSDI are the two that we deal with. SSI, Social Security, is SSI based on needs. If a person has a certain need and doesn't have income, meet certain criteria, they may get help in the form of SSI payments. That's separate from the disability claim, SSDI. That claim is based on an accident or a medical condition that has developed. Typically, the person has to be off work for a year, and they can file with their local Social Security office initially for either benefit. The process is a little different for either benefit, but I typically deal with the SSDI, which is the disability portion. I deal with injured people most often. So that process is you file the claim directly with your Social Security office, or you can have an attorney for you. Typically, that claim is denied unless you are severely disabled. The second round of that process is called a reconsideration. There's some forms you fill out, and it's all online now. So most of this is done on the computer as opposed to a piece of paper being filled out. The second process, once again, is reconsideration. You ask for a different group of people in the Social Security Administration to review the case. And then if that is not approved, you ask for a judge, an administrative law judge to hear the case. That's what takes the most time. There's usually about a year or so wait for a judge to hear the case. And so the whole process can take a couple of years. And I know most people who are in that circumstance don't have 2 years to wait. But I don't know of a way to speed the process up. However, more severe cases are approved on initial application reconsideration occasionally.
Okay. It is very frustrating when you're able to work and you want to work, and no one just wants to survive or live their life, the rest of their life off of any type of social security benefits. But unfortunately, it happens. So I would love to see the process sped up. But I know we talked a little bit about how people try to commit fraud against the system. So unfortunately, the good ones have to pay for the actions of the bad ones.
That's right.
So
Well, I think that goes, without saying, I brought up my mother earlier before she eventually passed away. She had a long fought battle to her benefits, due to the effects of cancer and the treatment and that, and she, like Louisa said, wanted to work. She was a nurse and she loved nursing and didn't want to give it up, but didn't have any other choice. And then, not only that, when she did get her benefit, like she applied, for food stamps and only got approved for $10 a month. But that's one meal. So this is unfortunate, but we're kind of in the bedside track.
and there's a lot of ups, downs, left and right with the system, and even though we're not talking about food stamps, but still, when it comes to getting assistance across the board because of some of the actions of people who have committed fraud against the system, well, the ones who desperately need those benefits, they have to suffer the consequences or go through scrutiny of having their life looked at through a magnifying glass because of other people's actions.
That's right. Well, we're getting ready to get to the end of the show, so we want to say thank you, Scott. Come by in the kitchen. It's the second Wednesday of each month. So our final question today, this is, I want to give some advice to anyone that wants to enter the legal field. It's kind of what it would take to get into the field and what advice you would give them as they get into their legal career.
I would say that any major in college is okay, but the two most important attributes I believe an attorney has is the ability to write and speak.
Okay.
Thinking you have to learn how to analyze problems, but being able to communicate, either writing or speaking, or so oral communication classes, composition classes, they're all important.
Okay. You definitely have to talk a lot and read a lot.
That's correct.
All right. This is Community Conversations on KWK 102.5 FM. Once again, we want to thank Mr. Scott Willhite for definitely stopping by. And of course, our live video is on Facebook, and plus it will be on there. And if you didn't get a chance to ask your question, you can still post questions, and we'll ask them again next month. Coming up tomorrow on Community Conversations, our guest will be Kelly Listenby. And then Friday, we have Javante Evans, Candace May, and Emma Agnew of Jonesboro Community Connections. And of course, if you'd like to be a guest on Community Conversations, you are the criteria. You must be a government official, you have to be affiliated with an organization, or just someone trying to make a difference in Jonesboro community. You give us a call at 870-277-1080, and we can probably get you booked on the show. And of course, we will be doing political interviews coming up this season, so we'll definitely keep you informed of all of the things going on so that you can be properly informed to elect the people that best represent your voice, because a voteless people is a voteless people. Your vote is your voice. That is something that I always say. Well, and when I get off this microphone, I ran my mouth enough. I'm going to let this beat ride out for the next 60 seconds. You enjoy it, and you guys be blessed. And remember, what's that catchphrase, Scott?
You gotta love mercy, act justly,
Love her. Say it one more time.
you gotta be just, merciful, and humble.
All right, that's Micah 6'8". This is Kelly K on 2.5 FM.